if you are here present in person in the courtroom, or if you're present via Zoom. If you're present by Zoom, make sure your video is on, but that your audio is on mute. Again, that your video is on, but that your audio is on mute. I would like to remind those accused who have been accused of said offenses that you have a right to remain silent about the facts of the case. Anything that you choose to discuss during the course of these court proceedings, whether it's in person or via Zoom, your statements can and will be used against you. You have a right to an attorney. You cannot afford one. Hopefully, all of you have had an opportunity to speak to the Public Defender's Office to see if you qualify for their services. Otherwise, you would need to appear in court either with your own privately retained attorney, or you have chosen to represent yourself. Keep in mind that if you choose to represent yourself, that you are responsible for understanding the law and the procedures and how they apply to the particular facts of the case. You are responsible for the impact of any legal decision you make upon your personal circumstances, upon your job, or your residency, or any other matters that may affect you, such as other open cases. All right. I have a few individuals who are not appeared via video, and I only have your name there as iPhone or Zoom user. That's not going to work for me because I don't know who you are, and you would need to make sure that you change your screen name to your correct name as it appears on your accusation. Let me see, what else do I need to address? Oh, okay. For those of you who are appearing in the courtroom, can I see by a raise of hands who do not have an attorney? Put your hands up, straight up. Okay, have you spoken to the public defense attorney? You need to speak to one of the gentlemen seated on the table very soon. All right, so Rockoff is signaling you to come forward. All right, now, those of you who are appearing via Zoom, if you've not spoken to a public defense attorney, you would like to see whether you qualify and could be, you could get appointed counsel to represent you, you would need to look at the chat feature, which is on your Zoom. All right, for those of you who are using a phone device, your Zoom screen may have 3 dots on it. You would need to click one of those 3 dots. You will see a pull-down menu, and there will be a chat option. From there, you should be able to see the messages on the chat feature, where how you can contact the Public Defender's Office to get an application so that you can submit it for review. Right now, I do see the information being sent in the Public Defender's Office. Okay. Let me go through my Orca E final calendar first. Is Francisco Rosado present? Francisco Rosado in courtroom?
No, I'm on Zoom.
All right, Mr. Rosado, I see you. You need to take your hat off and you need to have better lighting in your room. I can barely see you.
Yes, ma'am.
Okay. You need to put on a light other than your kitchen. Okay. And who's your attorney?
Mr. Watson, I actually just spoke with him. He said he's going to be there by 9:30.
9:30. Okay, so we will hold for his report, and you can mute yourself until Mr. Watson appears. Thank you.
Yes, ma'am.
Yvette Barlow, if you're present on Zoom, if you're present in the courtroom, it'd be a good time to stand up.
Good morning, Judge. That's my client. I expect her to be here.
Okay, so we'll hold for her.
Okay.
Your Honor, the ASG Riley for the state. Good morning. If Ms. Barlow does not appear by the end of the calendar, the state would request a bench warrant.
Okay, thank you. I do have a note here that she has to appear in person, so she has to appear in the courtroom. Hopefully, she'll be here before the end of the calendar. Mr. Rosado is here and we're going to take his plea as soon as his attorney shows up. Ms. Watson. Christopher Coleman. Christopher Coleman.
Good morning, Judge. I believe, and I'll just sound for him, but I believe Mr. Coleman's in the court, but that's my case.
He is in the courtroom. Are we ready to proceed with the plea?
Today, Judge, I've been reaching out to the state. I've been waiting for some video discovery. I've already entered in my appearance. I haven't received it yet, Judge. I'd like to review all the discovery before we move forward in this case.
Right, and who's the prosecutor?
Good morning, Your Honor, ASG Riley. And Miss Helen has all of the initial discovery. Videos will, if she's placing this on a trial calendar, videos will be provided 10 days prior to trial. But
So y'all are not submitting the discovery upon request now? The video? Y'all waiting till trial?
PD Helen just let me know last night, too late for me to send a video last night, that she did not have a video. So I will get it to her before, but if she's placing on the trial calendar, it is not the expectation that the state have all videos and discovery to the defense.
Can I have a seat, Mr. Coleman? Your attorneys, all right, let me see. Accusation entered October 2020. Discovery was submitted on June 8th, 2022. That was all the written discovery. The case was arraigned on June 10th, 2022. Counsel was substituted on October 3rd, 2022. I guess Ms. Gidding decided to enter an appearance at that time. And then January 22nd, 2023, Ms. Helen entered an appearance. Motions and demand for discovery submitted by Ms. Helen. That was on January 22nd, 2023. And what happened after that?
In Your Honor, if I may have the opportunity to speak, January 23rd, 12:03 p.m., I sent an email to Ms. Riley with the label body worn camera video discovery, informing Ms. Riley I have entered in my appearance and I'm specifically requesting the video discovery. That was sent in an email January the 23rd. So it was not last night that Ms. Riley got noticed. I requested it January 23rd specifically. So we don't have that, Judge, and I would like to review that with my client prior to making a decision in this case, whether it be a jury trial or a bench trial, or we work this out in a—
Ms. Riley, where's the video?
Your Honor, the response to Ms. Helen was when discovery was filed, it can be retrieved from Odyssey, and I will share the videos with her via evidence.com.
And was that submitted in response to the January 22nd?
Yes, Your Honor, I submitted a reply on Wednesday, January 25th.
No. Was the video submitted on evidence.com?
Yes, I shared it in evidence.com. I'm not sure.
All right, it's there now. Miss Helen, go look for it and we'll wait. Mr. Coleman, your attorney is going to be reviewing video that it should be on evidence.com.
And so, Judge, yes, I'll log on and I'll search it by the case number to see if it's there. If not,
Guys, it's already out there. I'm not going to go through this. I'm not referring your discovery. Y'all are grown folks. Y'all should know how to respond to demands for discovery, and folks who've made the demand should know how to retrieve them. Otherwise, I wouldn't be doing this job. I would be doing your job. So let's switch roles then. And that would make my life, I guess, a lot more difficult and maybe yours a lot more easier. Portia Dudley.
Portia Dudley.
Portia Dudley.
Yeah, that's my client. I talked to her yesterday and I talked to her this morning and she was driving here. She should be here shortly.
All right, we'll
I think we have a resolution of that case. She's supposed to bring her paperwork.
looking forward to that resolution. Thank you. Rashad Hunter. All right, Mr. Hunter, you're applying for the public defender's office? Okay, hopefully that'll work out. Have you finished the application? Just about, thank you. Alex Ecod.
Good morning, Judge Shantira Martin Stokes and Mr. Icar. We are here. We did receive finally a response back late yesterday, even from the solicitor's office. At this juncture, Judge, we're ready for trial.
Okay. This is Ms. Riley's case?
Good morning, Your Honor. This is ASG Get the Air case.
Yes. And Ms. Githier, Ms. Stokes and Mr. Icard are in the courtroom. And at this juncture, they would like to go to trial. Jury trial, I assume?
Oh, yeah.
All right.
Yes.
This case will be reset for a jury trial and a case management order will issue. And Mr. Icard, you have your bond order, so hopefully you're still in compliance. And we will see you at our next jury trial calendar.
Thank you, Judge.
Thank you. Thank you. Here you go. Jolene Lukes?
Yeah.
Yes, Ms. Lukes. Who's your attorney?
Your
Oh, this-
Honor, that is my case.
Okay.
I'm actually still working on Mr. Coleman's finding that evidence, video evidence on evidence.com, but I'll come back on here. It's the same announcement for Ms. Luke's case. I've entered in my appearance. I'm searching for the video discovery. I requested the video discovery in an email.
Okay,
So I'm still looking for the video discovery on evidence.com for both of those cases, Judge.
all right.
Your Honor, I thought Mr. Gaither was handling this case and I sent emails to him. And in that email, I stated that we had to re-request the body worn camera. I will forward that information to you, Ms. Helen. I thought Mr. Gaither was handling that case.
And I apologize, but evidently that was a mistake on the calendar because I actually had no idea who Jolene Lukes was. And so any email that came in regarding Jolene Lukes, I was trying to figure out who was the attorney so I could forward whatever email came to me. So I apologize for any inconvenience on my part.
Well, unfortunately, in that little mistake, Miss Lukes is in the courtroom. She was required to appear in person. Miss Lukes, which attorney, where is she? Which attorney have you been talking? Who?
It's me. Your
Patrice
Honor.
Helen? When's the last conversation you had with her? Okay. All right, Ms. Githier, the video is not available yet.
Yes, we had to re-request it, Your Honor.
Oh, boy. Let me see what's going on with Ms. Lukes. And what's the plea offer right now?
For a battery, it is 12 months to serve 3 days, credit for time served 3 days, balance probated, 10-week anger management class, 20 hours of community service, and no contact with the victim, Delilah DeMarte.
Okay. Looks like something was submitted on January 3rd, 2023.
There was discovery submitted on that day, but the body cam was not available and we had to re-request that again.
And it looks like Miss Helen entered an appearance on January 22nd. So Miss Helen, you didn't know about the mix-up in the council?
I didn't, Judge. I just, from my office, put in
Okay.
my entry.
Ms. Lukes, it looks like there was a mix-up in the public defender's office. One attorney didn't tell the other attorney that they had your case, and they haven't retrieved the discovery, and all the information was being sent to the wrong attorney when it should have been sent to Ms. Helen. So I'm gonna have to reset your case for your attorney to review the evidence as soon as it becomes available to them, and then we have to do this again. So I'm going to reset you to another final plea calendar, which is going to be March 3rd. Yeah,
Your Honor,
unless you want to go outside and talk to your attorney on the phone.
No, ma'am, actually, I'm going to be outside counsel.
Go ahead and come all the way across.
And then also, I think I did not state as far as count 2, that one would be null pros, in case I did not state that.
So On the battery, it's 12 months to go on probation, to do a 10-week anger management class, 20 hours community service, and no contact with the victim. And you will dismiss the hindering a person from making an emergency phone call. Okay.
Correct.
All right, Ms. Lukes, I required you to be here in person because I thought y'all were ready for a plea and that paperwork was going to be exchanged, and it's easier when you're here in the courtroom. But apparently due to the mix-up in the attorneys and the public defender's attorney, I'm going to have to reset your case one more month.
Okay,
And you are free to still be represented by the public defender's office at no expense to yourself. Or you can, I think you indicated you want something else.
yes, I want to seek outside counsel.
And have you taken any steps to do so?
Yes, I have.
And who have you spoken to?
Daniel Daughtery.
And what is the progress right now?
I'm just waiting to get the money for the retainer.
Okay.
Mhm.
So if you are telling me that you're planning to hire a private attorney, I guess she did qualify, but she qualified for the services of the public defender's office? Ms. Helen?
She did, Judge.
Okay. All right. I'm going to have the public defender's office withdraw. That means from this moment onwards, you don't have an attorney.
Okay,
Do you want to speak to Ms. Helen, or did you want to leave this courtroom without an attorney today?
I would like to leave without an attorney today.
Okay. Ms. Helen, if you want to submit a withdrawal order,
I will, Judge.
your next date is March 3rd at 9 a.m. in person. Whoever your attorney is, they must show up in court.
Okay,
No more delays. Would you like to write down the plea offer that's being offered by the state so you can convey it to your,
yes,
you would? Okay. Let's give her a piece of paper and pen. They offer you 12 months probation.
okay,
10 weeks of anger management. $20 hours of community service. And no contact with the victim. All evidence must be submitted by February 14th, including the video. Ms. Gipier, states on notice. You might want to write that down.
Yes, Your Honor, I have.
Evidence to be submitted by February 14th, 2023, or the case stands dismissed. Now, the problem, Ms. Lutz, all information about your case is normally uploaded online somewhere, evidence.com or through the case management system. The only attorneys who have access to this information presently is the public defender's attorneys. When your attorney comes on board, he or she won't have access to it because their file coming in late in the hour.
okay,
So they will have to go through some lickety steps to get the discovery. I am not considering any more extensions in this case for discovery.
okay,
All right. So your decision to change counsel at this late hour may make it very difficult for your attorney to get all the information by March 3rd.
okay.
So would you like to speak to Ms. Helen right now, or would you like to still leave the courthouse without an attorney?
I can speak with Ms. Helen.
All right. You have Ms. Helen's number?
Yes,
She has yours? Okay, take that piece of paperwork, sit there, and Ms. Helen will call you shortly.
okay, thank you.
Thank you.
Oh, I'll take this, okay.
Miss Helen, you have Miss Luke's number?
I do, Judge. When I give her a call, if she could step out into the hallway, please. Thank you.
Whenever you're ready. Thank you. Desmond McLeod. Christopher Campbell.
President.
Oh, sorry. There you are. And your attorney is Christopher Campbell?
That's correct, Your Honor.
All right. Christopher Campbell, I don't see Christopher Campbell on screen. Where's your attorney? Where is your attorney?
Should be on his way here.
Okay, why don't you step outside, give him a call or his office and let him know the judge is waiting for him. Thank you. Shantavia Stewart? Oh, there you are, sir. Okay. Yes, Mr. Watson. You're waiting for another, you got a plea, right, with Rosado as well?
I've got a plea for Rosado and I've got a plea for Timothy.
For Timothy,
Yeah, he's number one on the Orca East status.
oh, is it? Okay. Oh, all right. Thank you. Thank you.
Those are all signed, but Ms. Stewart's is the only one that I don't think the court had a copy of the signed, but I have it.
Do you have it? Can you email it to, or you have it in person?
I have it right now.
Okay, so I'm gonna take all your pleas up first, whenever you're ready.
I'm ready with the court's ready.
Oh, really? For all three?
Yes.
Oh, okay. Have all your, Mr. Rosado is on Zoom, and your other two clients, if they have to, definitely they can sit on the bench right there. All right? All right, we've got the police with Mr. Watson on deck. I have an add-on Orca B calendar, Christine Hacker, Mr. Gaither.
Yes, Judge, Ms. Atkinson. She's present, Judge. So she was, this was the young lady who missed the court date. Your Honor was able, the state had no objection to setting aside a bench warrant. Your Honor granted my motion, set the bench warrant aside and had her come in for today. But I think today is probably a procedure. I think this is a status conference.
No, well, she's on an add-on, so yeah. So we had a bench warrant that was voided on January 6th, and then we still don't have a good address on her.
Okay, we'll make sure she has that before she leaves.
Who's the prosecutor in this case?
Good morning again, ASG Riley.
And Ms. Riley, what is your plea offer?
The case has been sent to the district attorney's office to be reviewed for a transfer, but pending a response from them, the state's offer would be 12 months to serve 2 days, credit for time served 2 days, a theft class, and 40 hours of community service.
All right, Ms. Hacker, the prosecution in this court, the Solicitor General, which tries misdemeanor cases, has sent your case up to the district attorney's office or superior court to see whether they want to accept the case as a felony case. Do you know the difference? All right.
I'll explain that to her.
Mr. Gaither, it's a lot more serious, and I'm not going to mince my words about that, okay? I had issued a bench warrant against you because you did not show up in court the last time, but we set it aside upon your attorney's motion, and now you are required to be here in court. First thing I want you to do is go up to the, well, I need you to write down your current address, your phone number, and your email where we can reach you, because we don't have good contact information on you, all right? The second thing I want you to do is speak very seriously with your attorney, Mr. Gaither, and see whether you want to consider this plea offer, all right? I have no guarantee whether the district attorney's office is going to take your case as a felony or not. The major difference between the two is that if you're found guilty in a misdemeanor, you could be sentenced to up to a year in prison. If this case is accepted as a felony and the case goes to trial and the state proves the charges against you beyond a reasonable doubt, you could be sentenced up to 1 to 10 years. Do you understand? So this is a good time to speak to Mr. Gaither about your options. All right, Mr. Gaither.
So my next question then, Judge, is procedurally, do we just reset this
No,
case?
there's no reason. I want to know today whether she wants to take a plea, whether she
Oh,
wants to go to
okay,
trial,
okay.
or whether, and
Okay,
then
I thought
going
we-
to trial is going to
Sure.
mean pending review by the DA's office.
Okay, because I thought we had to wait for a decision. Okay, okay,
No, no, I'm laying it out for you.
got you.
All right,
All right.
okay. Tom Rousey, who's your client?
Good morning, Judge.
Morning.
Shouting Wang.
All right,
I'm not sure what.
got it.
number he is
Position
on the
number
calendar.
9.
Yes.
And this was reset from January 6th. All right, how are we all proceeding with this case?
Well, I think this is similar to the previous case with Ms. Gaithier. She sent me an email on Wednesday that she had to reorder the video. But there is an offer on the table. And I think my client is seriously considering it, but seeing that video might be the final piece that could get this done.
Reset to March 3rd at 9 a.m. And this is reset to the final 3 calendar.
All right. Thank you, Judge. Mr. Wang is on the Zoom conference, and if you recall, he had to travel back to China to see his ailing father.
I
But,
understand. Mr. Wang, what time is it there?
It's a 10:30 in the night. In
That's
the
what I
night.
got. Okay, well, I appreciate you being here till that late. You're free to go. You can come back on Zoom if you're still there on March 3rd. If you're still considering a plea, otherwise your attorney and you will discuss options, which you all can announce at that time. Okay?
Thank you, Judge. Have a
All right.
nice weekend.
Thank you. Tiffany Simmons, good morning. Tiffany Simmons, unmute, please.
Good morning. Good morning, Your Honor. How are you today? I'm here
Doing well.
for Attorney Keila Harris.
Keila Harris is.
Yes,
with-
Your Honor.
Okay, I see her. And what's the announcement?
What says the state? I know we had court in January. I haven't heard anything from the state. So what says the state?
The discovery was filed January 6th of 2023. And the state's offer is 12 months to serve 3 days, credit for time served 3 days, balance on probation, a family violence intervention program, a gun safety class, and to forfeit the weapon.
Okay, and who's assigned to this case? Because I would like to pre-try this case, Your Honor. This
That
is the
would-
first I'm hearing that I'm sorry, what'd you say?
All right, we're gonna put you in a breakout with Miss Riley, so please hold.
Okay, thank you, Your Honor.
Mr. Schaefer, who is in the courtroom, good morning, sir. And who's your client, sir? I know.
Mr. Alexander Hill, Judge.
I see it.
He is a spouse walking in the courtroom. He got lost getting down here.
Okay, so we're gonna hold for him then.
Yeah.
Okay, thank you.
And
Excellent, thank you. Are there any other private attorneys on the Zoom? Yes, Ms. Olga, good morning.
Good morning, Your Honor. I'm here on behalf of Ms. Jessica Wall, who's also on the Zoom conference.
All right, and what's your announcement?
Yes, Your Honor. I did receive the link to the supplemental audio discovery this morning.
Hallelujah.
We've been in communication. I've been in communications with Ms. Githia regarding resolution. We've not reached resolution yet. So
what is holding up the resolution?
well, I was waiting for the discovery, Your Honor. And
I thought you
also
got, didn't you say you got it?
this morning I did, but we have been
Okay.
previously discussing the resolution, while waiting for the discovery for Ms. Githia to be able to get that additional
You said
discovery.
Jessica Wall is present. Where is she?
She's on the Zoom, Your
I
Honor.
see her right there. Okay. All right. Miss Olga, review the discovery, speak to Miss Wall, and then I'll pick you in a breakout with, is it Miss Githia?
Yes, Your Honor.
All right.
Well, Your Honor, I'm sorry, I apologize. I was going to say, but I think that regardless of that, we can put the case on the jury trial calendar.
No, y'all have had it now. I don't know why the state was so late. But I want you all to discuss it and tell me whether you're going to trial or take a plea today.
Yeah, that's what my announcement is. We can put it on the trial calendar.
Oh, you want a trial? You don't even.
Yes,
But you haven't even reviewed the rest of the evidence.
well, it's the 911, as the recording of the 911 call.
How long is it?
I'm not sure. I haven't even accessed it yet because I just got it this
Okay,
morning.
so back to my original announcement. Review the evidence, speak to your client, and then you're going to break up with Ms. Githier and tell me what's holding up the resolution.
Okay,
All right.
may I exit the Zoom and then come back on?
Yeah, but your client
Okay.
is not free to go.
Okay, thank you.
All right. Any other private attorneys on the Zoom?
Yes,
Oh, and
Judge,
of
I'm
course-
here.
Okay, Ms. Kurt, just give me one moment. Yes, sir. Yes, sir. That was on the plea calendar. Is your client taking a plea today?
Waiting for the body camera videos. I think the state ordered the body camera videos and the audio wasn't working, so they have to reorder the videos.
Which case is that? That does sound familiar.
Position 8, no, it's position 8 on the Orca final plea.
That is correct, Your Honor. The body cam did not have audio, so it had to be re-requested.
Okay, reset to March 3rd, 9 a.m. And the video must be produced and delivered to the defense by February 14th, or the case stands dismissed. Any questions?
No questions, Your Honor. Thank you.
All right, this is reset to the final plea calendar, must appear in person. Thank you. Up to the defense to let me know if y'all get it by February 14th. Okay, and Ms. Kurt, which case do you represent?
Randall Smith.
Give me that name
Position
again.
Position 7 on the Orca East status.
Oh, okay. All right.
Judge.
Yes, Ms. Kurt, Randall Romero Smith. This was reset from January 6th for compliance. What were the compliance requirements?
Judge, we've submitted completion of a drug and alcohol evaluation to the state as requested, and he's prepared to pay the $300 plus court costs today.
And who's the prosecutor, Ms. Riley?
Ms. Githier, Your Honor.
Ms. Githier, and if he does all that, what is the state going to do?
The state will null pros.
All right. Have you received the proof of payment and the proof of the ADT?
I have the proof of the AEDT, and Ms. Kurt did ask about the payment, how he can do the payment ahead of time. Was he able to do that?
Nobody responded with a link or any way he could pay, but he's prepared to pay.
Where is he?
He's on the call.
What's the payment for, by
here.
the way? Ms.
Excuse me,
Githier, what's the payment for?
It was a $300 fine plus court costs.
You're going to fine him for a charge of which you're not going to convict him?
Your Honor, the resolution with this matter at hand was to do the alcohol drug evaluation and treatment, do 30 hours of community service, or do the fine, and he opted to pay the fine.
Oh, I see. Okay. Instead of doing 30 hours community service.
Correct.
I suspect it's a fee instead of a fine, since it's an all pros.
All right, we're going to call it a fee then. And to whom does he pay the fee, Ms. Githier?
That he would have to pay to the clerk's office, Your Honor.
All right, Ms. Redden, can you help me out with that?
I don't know how to attach a fee to a charge.
It's not crossed. Yeah, that is the problem we have, Ms. Kurt.
Judge, there isn't a diversion fee he could pay.
This case has not been sent to diversion. It's a procedural issue. Okay.
Your Honor, he has completed the alcohol drug evaluation and treatment. We will know across the case.
All
We
right.
will accept that.
Is the $300 fine is a fee is suspended? The case is null pros. Thank you, Ms. Kurt.
Thank you, Judge. May I be excused?
Yes, thank you. Yeah, Mr. Smith, Thank you for completing the ADT. You're free to go.
Thank you.
All right.
Excuse me, Your Honor.
Yes, Ms. Simmons?
Yes, is the breakout session going
It's
to
coming.
be?
It's coming. It's coming.
Oh.
It's coming. Be patient.
Thank you, Your Honor. I
All
just
right.
didn't know I missed connection. Sorry.
Are there any other private attorneys on the Zoom? Okay. Mr. Watson, for all your three cases, who's the prosecutor?
For Ms. Stewart, the prosecutor is, Ms. Gitier.
Okay, so Ms. Simmons is going into a breakout with Ms. Riley. Mr. Glanville?
Other two, please, are with me, Your Honor.
Okay, we're gonna take one. Shoot, okay. I need the prosecutor, so Ms. Simmons, you still have to go. All right, who we taking first, Mr. Watson?
Ms. Stewart.
Let's do it, okay. This is State versus Shantavia Stewart, accusation number 20 CR 005722E. Ms. Stewart was originally charged with battery, domestic violence, and cruelty in the children, third degree, from November 20th, 2020. Ms. Stewart is present and represented by counsel, Mr. Shafar Watson. Is that correct?
Shofatia.
Shofatia.
Close enough to.
Okay, Shofatia Watson. And Mr. Stewart, you've been advised of your right to remain silent. You were in the courtroom when I gave the announcement. All right, and you also have a right to an attorney, and you're represented by Mr. Watson. So this is going to be a negotiated plea hearing where the state has made a recommendation to which you and your attorney have reviewed. I'll be asking you some questions to make sure that if you accept this recommendation, that is being done willingly, knowingly, and voluntarily. All right? Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Judge.
Thank you. Mr. Riley, what's the plea offer?
This is my case, Your Honor. And
Ms. Gippier, sorry. What's your plea offer?
the offer is the battery will be reduced to disorderly conduct.
That dog shit got a lot of shit.
Just 1 minute. Sorry, Ms. Gippier. Okay, sorry about that. Ms. Gippier, okay, go ahead, Ms. Gippier.
The battery family violence will be reduced to disorderly conduct. Is 12 months probation, 4-week anger management, 40 hours of community service, and no further violent contact with Portia Dudley. And the cruelty to children in third degree will be null prost.
All right. Mr. Watson, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
Judge, I stipulate to the factual basis. My client does accept the terms, and I would just point out to the court that Ms. Gitier and I agreed that once Ms. Stewart completed the terms and conditions of probation, that her probation can early terminate.
I don't see any problem with that. Do you, Ms. Gippier?
No, Your Honor.
Okay. All right. Ms. Stewart, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
I am.
And having reviewed the recommendation, do you feel that anyone is forcing you or inducing you to take this plea today?
No, ma'am.
As your attorney has explained to you, if you accept this plea today and plead guilty to disorderly conduct, you will be waiving your constitutional right to challenge the original charges in a court of law. You will not be able to go back to court to confront your accuser, examine witnesses, challenge the state's evidence, present any defenses if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of disorderly conduct?
Guilty.
Your sentence is 12 months to be served on probation. You will be, while you're on probation, you will complete 4 weeks of anger management classes, 40 hours of voluntary community service in any nonprofit agency, which is not a school and not a church. Understood? Not a religious organization. You may continue to have contact with Portia Dudley, but there cannot be any violent physical or verbal altercations. All right. You will report to probation next Thursday at 132 Mitchell Street in downtown Atlanta.
Okay.
At that time, you will set up a probation case and report to probation every month until your conditions are completed. If they're all completed to the officer's satisfaction, your probation is terminated. All right. Any questions?
No, ma'am.
All right, next Thursday before 3 o'clock, probation office. Thank you.
Thank you.
Mr. Watson, your next client is.
If we can do Mr.
And
Rosado.
also, if you can send me a copy of the signed plea paperwork when you have it, when Mr. Watson has completed it.
Ms. Redden will do so. Thank you. All right, I'm sorry, Mr. Watson, who was next?
If we can do Mr. Rosado next.
Yes, Mr. Rosado. Okay, I see him on the Zoom.
Yes, Judge, he is.
All right.
Yes,
Mr.
ma'am.
Rosado. Okay, do you see your attorney at the podium?
Yes, ma'am.
All right. This is State versus Francisco Bibliani Rosado. Mr. Rosado's, excuse me. Case number is 20 CR 005-094E. Mr. Rosado is appearing for this plea hearing virtually on Zoom, and his attorney is present in the courtroom. Attorney being Shopatea Watson. Mr. Rosado, you've been advised of your right to remain silent. And in this negotiated plea hearing, I'm going to be asking you some questions as to whether you're going to accept the state's recommendation freely, willingly, and voluntarily. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Riley, what's the recommendation, please?
It's 12 months probation, a family violence intervention program, to have no further violent or harassing contact with Tonisha Temple. Probation to terminate upon completion of the family violence intervention program.
All right. And he was originally charged with battery. And is the state going to null cross that charge?
I'm sorry.
Mr. Rosado, he was originally charged with battery, domestic violence, and disorderly conduct. Is the state going to null cross I only see the one count of disorderly conduct on the plea paperwork.
Yes, Your Honor, I should have amended, the charge was amended to disorderly conduct. But if there is still a charge showing, the state would be null crossing.
Let me make sure.
Mr. Rosado, put your hand down, please.
Sorry. I have too many final plea calendars. Okay, there we go. Yeah, I do see both the charges still listed on Odyssey. So I would need a null cross on the battery charge.
Yes, Your Honor.
Okay. All right, Mr. Watson, based on this information, does your client accept the terms of this plea offer for one count of disorderly conduct? And do you stipulate the factual basis, venue, and ID?
Judge, we stipulate to a factual basis, and considering the conversations I've had with Ms. Riley and my understanding that we're only proceeding on count one, disorderly conduct, and the state's representation that they will be null crossing the battery charge, my client will accept the plea as presented.
All right. Mr. Rosado, you've already been sworn in. Have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am, I am.
All right. And is anyone forcing you or inducing you to take this plea offer today?
No, ma'am.
Based on your conversations with your attorney, just to reiterate, if you decide to plead guilty to disorderly conduct, you would have to give up your constitutional right to go back to court, to have a trial in front of a judge or a jury, to be able to challenge the state's evidence, examine witnesses, confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of disorderly conduct?
Guilty. I have a question. I apologize for Mr. Watson, if I can.
Well, you'll need to call him. He'll need to step out of the courtroom, and then you'll have to wait before I can take up this case again.
My only question is, I was under the impression it was 6 months, not a year. That's all it is, ma'am.
Listen very carefully. Listen very carefully. The probation is for 12 months. The classes are for 6 months long because it's 24 weeks of classes. If you complete
ma'am.
the 24 weeks of classes, your probation will terminate. That's why it's 6 months, if that was your impression.
And Judge, I apologize. I believe Mr. Rosado is correct, and Ms. Riley, correct me if I'm wrong. But I think we did talk about this being a 6-month probation term based on the disorderly conduct.
It'll be tough. It'll be
Well-
tough because he won't be able to complete 24 weeks of classes in the 6-month sentence.
Okay, and I think Ms. Riley is shaking her head no, Judge.
No, because 6 months is the county disorderly charge, and we can
Okay.
only charge a state disorderly, which is 12 months.
All right.
But it can terminate upon completion.
Okay, so that was a different discussion.
Okay.
Mr. Rosado, you are correct. So are we going with as an ordinance violation or a state law violation?
It's a state law violation. We cannot in state court charge the county ordinance for disorderly.
Okay, so technically speaking, Mr. Rosado, you would be on probation for realistically up to 7 months. And if you complete the classes, quickly, within the next 6 months, then your probation will terminate. So do you still want to proceed with this plea?
Yes, ma'am.
All right. So it says 12 months probation. So again, how do you plead to one count of disorderly conduct?
Guilty.
Your sentence is 12 months to serve on probation, during which time you will complete the domestic violence intervention program. At all times while you're on probation, you have to have no further violent contact with Tanisha Kemple. That means no physical or verbal altercations, although you may communicate with her if she wants communication with you. Upon completion of the domestic violence classes, your probation will terminate. You will report to the probation office next Thursday before 3 p.m. Hopefully you're writing this down.
Ma'am, is that in Atlanta?
Yes. And it is at 132 Mitchell Street in downtown Atlanta, 30303.
Judge, believe the court was made aware through the motion to have Mr. Rosado on the Zoom for the plea that he resides in Jacksonville, Florida.
Okay.
So I think, and Ms. Riley, correct me if I'm wrong about this part, but I believe the agreement was that he could do probation via mail or call-in.
Are you going to go to the probation office for him next week, Mr. Watson? To set up his probation case?
On what date, Judge?
Next Thursday, before 3 p.m.
Sure.
All right. So you would have to be at the probation office by February 9th before 3 p.m. at 132 Mitchell Street. And I will allow for telephonic reporting, and he would need to show proof that he's enrolled in a domestic violence class or program in Jacksonville, Florida. And Mr. Watson, please be sure that the school where he enrolls is acceptable to the probation office.
I'm sorry, Judge, can you repeat that, please?
Whichever domestic violence program he enters or enrolls in Jacksonville, Florida,
Yes, Judge.
that program must be acceptable to the probation officer.
Yes, Judge.
All right?
Yes, Judge.
Okay, any other questions? Mr. Rosado, any questions?
No, ma'am.
All right, good luck, sir. Thank you.
Thank you.
Your third case, Mr. Watson?
Judge, that's going to be Timothy Fulton.
Timothy. Is he present?
He is present, Judge.
Thank you. And Ms. Riley, are you with this case?
Yes, Your Honor.
All right, this is State versus Timothy Fulton, 20 CR 005-496E. Mr. Fulton is present in the courtroom with his attorney, Mr. Watson. Mr. Fulton, you have been advised of your right to remain silent, and you'll have counsel to represent you at this plea hearing. Mr. Fulton, Does he have another open case, 20 CR 0054443E?
Not that I'm aware of, Judge. I do know that there is a cross defendant, but I don't know if that has anything to do with him being a defendant in a second case.
Yes, that would be number 4, Your Honor. I represent her.
Ulysses Shill? Is that your client, Mr. Rocco?
Yes, yes, sir.
Okay, is she present?
I thought she would be on Zoom.
Ulysses Shield? All right, that's the cross defendant. All right. All right. Mr. Fulton, may I place you under oath, please? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Riley, are you waiting to have a breakout with Ms. Simmons, or was that Ms. Githier?
It is me, but this is also my case, Mr.
Okay,
Fulton.
no problem. No
Okay.
problem. Okay, so we are addressing this negotiated plea hearing, and what's the state's recommendation?
It is 12 months probation, complete a family violence intervention program, and to have no further violent or harassing contact with Ulysses Shield.
All right, and this is also pleading guilty to disorderly conduct?
Yes, Your Honor.
All right. And let me just make sure I don't need to null cross the battery, or rather the state doesn't need to null cross the battery.
No, Your Honor, this again was amended. The simple battery was amended to disorderly conduct yesterday. I'm not sure if they have accepted it yet in the clerk's office.
Oh, yep, that one was all set. Okay, Mr. Watson, that shows only as disorderly conduct, not simple battery. Okay. So 12 months FWIP, no violent contact with Ms. Shield. And Mr. Watson, does your client accept those terms? And
Yes, Judge. Pardon me. He does accept the terms. I had a conversation with Ms. Riley concerning this case, and we agreed that Mr. Fulton's probation can early terminate once he completes the terms and conditions of probation.
all right,
The state does not have an objection.
all right. And you stipulate to the factual basis, venue and ID, yes?
So stipulated.
Okay. Mr. Fulton, have you consumed any medication or alcohol recently?
The only thing I'm taking is,
You don't have to tell me the medication.
it's a special eye drop.
Okay. Does that impair your ability to understand what's going on?
Sometime.
Are you able to understand what's been going on right now?
Yes, ma'am.
And have you understood everything that we've been transpired right now in the courtroom?
Yes, ma'am.
Okay.
Because, Judge, excuse me.
No, please. Do you understand what's going on? Okay.
I'm just concerned that if you've consumed any medication, that you're not loopy or,
Okay.
dizzy. All right, so I just want to make sure that you understand everything that's going on. Are you satisfied with your attorney?
Yes.
Is anyone forcing you to take this plea today?
No.
All right, and in your discussions with your attorney, you have covered this, but let me repeat it. If you decide to plead guilty to disorderly conduct, you would have to give up your right to go back to court and have a trial in front of a judge or jury. You will not be able to confront your accuser, examine witnesses, challenge the state's evidence, and have the prosecution try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of disorderly conduct?
I plead guilty.
Repeat.
Guilty.
I heard guilty. Is that correct?
Yes, Judge.
Okay. Your sentence is 12 months, during which time you will be on probation. You will complete a 6-month domestic violence intervention program. That's 24 weekly classes. After you've completed those classes, your probation will terminate. At all times, you have to have no violent physical or verbal altercations with Miss Alicia Shield. Any questions?
No, ma'am.
You will report to the probation office next Thursday, February 9th, before 3 p.m. at 132 Mitchell Street in downtown Atlanta. I wish the address was 123, it would have been easier, but 132 is what I gotta live with, all right?
Yes, ma'am.
Okay, sir. If you have no other questions, you're free to go. Thank you. Oh, Mr. Fulton, if you please remain, we're going to give you a form to fill out so we can send it to probation. They can get your case ready. Okay. Mr. Watson, anything else, sir?
No, Judge, that concludes my business until February the 9th.
All right, so you have a great weekend. Thank you.
All right, Judge, thanks. You too.
In your honor, I have a few announcements.
All right.
From the Orca final plea calendar. Christopher Coleman, Judge, I've just reviewed that body worn camera discovery. I'd like to review that with Mr. Coleman, if we can just get a reset to the next final plea calendar.
I was gonna say.
And have you got an offer? Ms. Helen? For
I do
Christopher
not.
Coleman?
I do not have it written here. If the state could read that for the record.
Christopher Coleman, do you have an offer?
Yes, Your Honor, it was relayed via email, but it's 12 months to serve 30 days. Credit for time served 9 days, 21 days remaining to be served. The balance on probation, a family violence intervention program, 40 hours of community service, and to have no contact with the victim, Jasmine Clark.
Okay, so additional jail time is called for. Christopher Coleman, he is present in the courtroom, yes? Okay. All right, Mr. Coleman, it looks like your attorney wants to speak further with you to relay with you the evidence she's reviewed, as well as the state's offer. So I'm going to reset this case to March 3rd at 9 a.m. on the final plea calendar, just like today. At which time you and your attorney will let me know whether y'all are accepting a plea offer or a modified plea offer or want to engage in a non-negotiated plea or go to trial. All right. Make sure your address and your contact information are current with us at all time. And we'll see you on March 3rd, 9 a.m.
And Your Honor, I don't mean to interrupt you, but can Mr. Coleman update his address while he's in court there with his current address? Is that possible?
You have all that information written down? All right, where does he have to go to update it? Upstairs? We are open now? Oh, okay. You need to go upstairs to the first floor to the clerk's office. You need to show an ID and update your address, your phone number, and your email in writing before you leave the courthouse. All right. Thank you, sir.
Thank you so much, Judge.
All right.
I
This is
do.
reset, final plea. Makes the word final seem oxymoronic at this time, but March 3rd, 2023 at 9 a.m. All right. Okay. Yes, Mr. Go.
If I could, on the same calendar, number 5, Hunter, Rashad Hunter, he does qualify. We would ask for a pre-trial. There's a possibility we might resolve that.
Okay.
Number 4.
Oh, hang on. This is going to be Miss Riley, and you want to break out
Riley,
with
yes.
her. Okay. And number 4, yeah.
She's here. She showed up. She has the paperwork. Miss Portia, you'd stand. She has the paperwork for her anger management. She's done her anger management and her community service. We need to show. We need to
All right. And you sit with Miss Riley?
I need to get this paperwork to Miss Riley, I guess. Yes.
Yeah. Okay. Why don't we see if we can get? You got it in. Yeah. Miss Riley, Miss Redden is going to scan and email the documents that Mr. Rockoff has just presented for Portia Dudley, and then you can review that. I think she's here for compliance.
But Your Honor, that is not what I have. I have Ms. Portia Dudley as a dual arrest case. I sent the offer to Mr. Gaither that it was 6 anger management classes and 40 hours of community service. Is that what she has? It was not an offer.
I think what's happening is that cases that were formerly represented by Javier Trejo or Mark, I forget the other gentleman's name.
Rose Woodbury.
Yeah, some of those, for some reason, they're appearing on the calendar under my name, when that's not exactly, should not be accurate. Because some of those cases were given to Mr. Rockoff and some of those cases were given to Catrice, Helen, or the lawyers.
So I don't want to get into that.
Sure.
Well,
But what I do want to get into is number 1, Portia Dudley is represented by Mike Wolfoff. Okay,
Okay,
that's an indisputable fact.
well, Miss Portia Dudley was here at the last calendar. I discussed the case.
With whom?
Mrs. Riley, I thought, and yeah, 8 hours of anger management, 46 hours of community service.
No, listen, Mr. Rockoff.
Pardon?
When your client completed those programs,
Yeah,
was she under the impression that she was completing them because of compliance in exchange for perhaps a dismissal?
right.
Or was she completing them in anticipation of that's what she's going to plead to?
No, we were anticipating a non-price for completion of the 8-hour anger management.
So your discussions with the prosecutor was in,
Yes,
I have not discussed a dismissal for this case. I have that it can be reduced to disorderly conduct.
all
I've
right,
got a note on my file, January 30th, 2023.
all right. Miss Dudley, do you need to speak to Mr. Rockoff?
No, I was under the impression that if I completed 6 hours of community, anger management and 40 hours of community service, that it would be dropped to disorderly conduct.
And who gave you that impression?
The lady with the blue behind her,
The who?
the lady in the, Miss Riley, is it Miss Riley?
You didn't speak.
So you didn't say disorderly conduct?
Well, she says, she's
It's a
agreeing.
plea
with
to
Riley.
disorderly conduct. It is not a dismissal.
Right.
Yes.
I did not convey that offer to anyone because I have not had this case before.
All right.
May I speak?
I stand corrected.
My understanding was that I would plead to disorderly conduct if I completed those hours that were requested. And then I remember judges said I could go ahead and get started. And once I completed what was required of me, I would not be put on probation.
All right.
I understand it. So
Then your understanding is consistent with what Ms. Riley offer is, okay? So then my next question is, Ms. Riley, do you have the plea paperwork ready for Ms. Dudley?
No, I don't. I have not had any communication with Ms. Dudley or Mr. Raffoff or anyone. So I did
No
not know
problem.
it was going to be a plea.
No problem.
I will get it done.
Thank
Sure.
you, Ms. Riley.
You're welcome.
All right, Mr. Roffoff, this will be a plea for Portia Dudley to disorderly conduct. And we will accept the documents that she submitted to see whether she's completed all or in part of the conditions of this proposed plea. And as soon as Ms. Riley sends the paperwork to Ms. Redden, we will have them printed for Mr. Roffoff and Ms. Dudley to review. All right. Ms. Dudley, please stand up. I want you, me, Mr. Roffoff, and Ms. Riley to be all on the same page. You have agreed to plead guilty to disorderly conduct in exchange for completing anger management and community service, correct?
Yes.
And if I find that you've satisfactorily completed all these conditions, then probation may not be required. And is that correct, Ms. Riley?
That is correct, Your Honor. However,
Okay.
I will also state that because I did not have prior notice that this was going to be a plea today, I will go ahead and amend the accusation. However, it's not going to show in the system until the clerk's office has had a chance to accept it.
All right, as long as we have you on record saying that you're planning to amend it, that's good enough. All right. Are we all in sync with what the decision is? Excellent. Okay, thank you. Please hold, you'll get the paperwork to review. Okay,
And Judge, I do have an announcement on the same
just one
calendar.
second, sir. Mr. Schaefer, what's the status of your?
Yes, Judge, my client is here. We're ready to proceed. I do not see Erica Marshall's story though, for the state.
This is position 3 on the Orca E status calendar, State versus Alexander Hill. Violation of a restraining order, TPO. Were you waiting on a plea offer or were you waiting on a?
Judge, let me just say right now, I'd love the state to announce what the state's position is. We've got extensive written communications and I've got some issues with this, Judge. This is a 2018 TPO that was allegedly violated. This case has a long history of inaction. And I had extensive discussions with Erica Marshall Story, and I want to make sure that the state was brought up on those and is current with them before an announcement.
Miss, I don't know, Mr. Prosecutor.
It would be Miss Riley.
Right.
The state, and yes, I have spoken with my colleague, Miss Marshall Story. The state's offer in this case is 12 months to serve 1 day, credit for time served 1 day, the balance on probation, 8 anger management classes, and to have no contact with the victim, Amanda Pregisbin.
Judge, that directly flies in the face of the written communications that I have extensive evidence of. We've gone as far as to complete the alcohol drug evaluation that was suggested by Ms. Story in exchange for a dismissal. I've gone as far, judges, to actually request her to email me in specifics, and there's a pattern where the solicitor's office has failed to follow up with written
Do you
communication.
have the one email that says I'll dismiss if he
Oh,
completes?
no, Judge, they won't put anything in writing, even after you have the conversation and request an explicit memorialization of the offer you just had on the telephone. And I'm not in the habit of recording telephone calls,
So,
but I'm gonna have to start doing that.
all right, Mr. Schaefer, are you open to a breakout with Miss Riley?
Not really, Judge. This case is an absolute waste. My client has had no contact with this woman. The state could not locate the woman for a substantial period of time. And last time this case was reset on terms. So the state did eventually reach this woman where there's been no contact at all. This case started in 2019.
I know. And I'm trying to figure out, whether Mr. Hill has had any other issues since.
No, none, Judge. And he's present. He's been participatory. He has been begging to move on with his life.
Your Honor, the state would just ask for it to go to a jury trial.
Judge, that's an absolute objectionable. We're going to ask for this court to enter a dead docket. I can file a constitutional speedy today and would ask for this court to hear that constitutional speedy.
Yeah, do that.
And that's fine.
Absolutely.
Yeah, and we will have that on a motions calendar. Actually, I'll move it to March 3rd.
I would ask the court to also specifically request the solicitor's office assign a prosecutor to this case so that I can have a point of contact, being that the point of contact has changed so many times
Well,
during the pendency of this case. And I believe it's reached a point of frustrating the goals of justice.
understood. March 3rd, status calendar at 9 a.m. We'll have your motion addressed. And Ms. Riley, I'll need Ms. Marshall Story to appear for this case.
And Judge, we would ask that all solicitors would be required to appear in person in court with us rather than virtually. The uniqueness of creation and the requirements of the Sixth Amendment would necessitate that for the efficient promise of justice.
I'm going to
Your Honor,
require
if
Ms.
it's a
Marshall
motion
Story to
calendar-
appear in person.
Thank you very much, Judge. Judge, that concludes my business. May I please be
You're free to
excused?
go.
Your
Thank you,
Honor,
Judge.
this case is a solicitor's office case, so a solicitor will be available. Ms. Marshall Story will no longer be with the office on March 2nd.
Oh, Mr. Schaefer, I'm sorry. Ms. Marshall Story has left.
And if this is a motion,
No,
I would
hang on.
request that it be placed on a motions calendar.
No, it's
Yes,
going
those
on my
are the
status calendar on March 3rd. I can-
And Judge, we would request Mr. Gamage be present.
Okay,
Thank you very much, Judge.
we will have any other assigned prosecutor who's familiar with the case. If that includes Mr. Gamage, then that's Mr. Gamage.
I would like Mr. Gamage because this judge,
I cannot compel a particular prosecutor if the prosecutor with whom you've been discussing the case has left the office.
thank you,
That-
Judge.
That is that prosecutor's voluntary decision.
Yes, Judge.
But whoever's the assigned prosecutor for this case must appear in person on March 3rd, 9 a.m. on my status calendar where we're going to address this motion.
Judge,
Your
if
Honor,
I
will there
also
be
may
a court
also
reporter?
note.
Please,
just while
Mr.
we're
Schaefer,
here-
One
excuse
person
me.
at a
Yeah,
Will
time.
there be a
Ms.
court
Riley, I'm
reporter?
speaking, please.
I
Judge,
was speaking
I'll
first.
also note that the solicitor's office, or sorry, the clerk's office, if you look on Odyssey, does not even indicate where this hearing is supposed to be. It merely says Orca hearing. We had to call to find out where this court is actually asking these cases to appear. The system, if you look it up right now, does not even have a court assigned. I had to reach out to the solicitor's office who could not tell me who was handling this case. They had to look and find out where this case was scheduled.
So I don't see the notices that are sent out, but I'm looking at it, it says courtroom G33.
That's
So-
brand new as to yesterday. I believe we have a printed copy of the public register yesterday that shows that it was just labeled as an Orca case
Okay.
with no courtroom and was
we will take
originally
that-
signed to Judge Morris.
We'll take that up with the person responsible.
Your
for the
Honor,
notices. Thank you.
will a court reporter be present in the courtroom on March 2nd for a status?
Yeah, I'll have one present, no worries.
Thank you.
And Judge, lastly, could you please confirm or request the state to confirm or deny whether they've received the submitted alcohol drug evaluation?
Ms. Riley, do you have the completed ADAT?
ASG Riley does not.
Okay.
Judge, I'd like to note that has been submitted. I would ask the state right now to,
Mr. You just asked me to confirm, she did not.
thank you, Judge.
That's all we can do.
Thank you, Judge.
All right, we'll see you on March 3rd, status calendar. Ms. Redden, can we make a note that I need a court reporter?
Thank you, Judge.
All right, thank you. All right, excellent. Let's move on. Ms. Simmons has already had her powwow with Ms. Githia.
No, it was.
No, Your Honor, I'm with ADA Riley, and we did not have a breakout session. However, I have sent several messages to her in the chat. Your Honor, is it possible that we can go ahead and get the reset and her and I can speak offline? Because there's
No.
definitely
We
some
can go,
fundamental.
you can go in a breakout now. All right, Mr. Glanville, please place Ms. Riley and Ms. Tiffany Simmons in a breakout. Okay.
And Your Honor, I
Yeah,
would like to
and-
revisit one case.
As long as it's not Ms. Riley's.
Oh, I don't.
Breakout.
I'm not even sure. But I want to make the court aware that Miss Yvette Barlow, position 1 on the final plea calendar, is here.
Oh,
And she's
excellent.
been here for a little while. As a matter of fact, I've actually spoken to her. Ms. Riley, I'm sorry. There
Where's Ms.
we go. I met Miss Barlow. Miss Barlow. Yeah, she's here, Judge.
Okay. Were you here all the time?
No, she was late. She was
Okay,
late, but she
all
did
right.
come in
She came
shortly
in,
afterwards.
bench warrant set aside. Excellent. Okay. And she's on the final plea calendar. So you're ready to go forward with the plea?
No, we're not. And what I need is, what is the state's final offer, simply because I may have, and this may be my mistake, but this was a case that I inherited. And so what I need was the state's offer, because I may have the wrong offer.
Okay, as
I
soon
just
as
wanna-
Ms. Riley is available.
That's fine. That's
you
fine. I can wait for her.
Okay. Porch Dudley, we're waiting on the plea paperwork.
And then let me revisit Miss Christine Hacker on the
Yeah.
add-on Orca B calendar. Miss Githia, was that your case?
Is Ms. Githia
I'm
present?
sorry, repeat which case that was again?
No, number 1, on the add-on Orca B calendar, Miss Christine Hacker.
That's Ms. Riley's case.
Miss Riley, okay.
Yeah, that's Ms. Riley.
Okay.
Okay. Let me go back to my status calendar. Position 1 was plea, Fulton. Position 2, Ms. Riley is in a breakout with Ms. Simmons. All right. Alexander Hill is reset to March 3rd, 23 for motions. Need a court reporter. In person for all parties. Position 4, Mr. Arthur, Alicia Shield, could you tell me again?
I thought I did talk with her last week. I sent her an email this morning, no response, but I did expect her. She's always been here. But
We're still waiting for her?
yes, we're still waiting.
Okay. Kimarla Shivers.
That is my case, Judge. Ms. Shivers is present.
All right, that's good. And what are we doing?
Let's further notice this to the final plea calendar, Judge, and I'll tell you why. I had really bad technical problems getting her copies of videos and photographs that the state provided to me. So I had to download all of that and put it on a zip drive and hand delivered it to her this morning. And so we need to have an opportunity to have another discussion now that she has what I have, so we can talk. But we're probably not gonna be able to work out a resolution today, Judge.
I'm going to put this on the trial calendar. The case management order has already been issued.
Okay.
The case management order was issued January 6th, so the clock is ticking already from January 6th.
All right.
This is a jury trial, correct, Your Honor?
That's correct. All right, Ms. Shivers, your case is going to be reset for a jury trial. You're going to be represented by the Public Defender's Office. If y'all will reach a resolution before that, then we can address it before the jury trial. You'll need to ask for it to be put on a plea calendar.
Okay, thank you, Judge. Is Ms. Shivers free to go?
Yeah, Ms. Shivers is free to go. Joanne Slater. Joanne Slater, S-L-A-T-E-R.
Your Honor, it was my understanding that the attorney Tanya Miller was on legislative leave.
Yeah, she is. Is Joanne Slater present?
I'm here.
Okay. All right, so Ms. Slater is not present. She is on legislative leave and we haven't reached even the halfway point yet. So this is going to have to reset to the.
Miss Slater is the defendant. She's on Zoom.
Oh, no, I meant Miss Miller. Miss Miller, Miss Slater, your attorney, Tonya Miller, is still, I guess, busy with state affairs. So I'm going to have to reset it for another 30 days to see if she's available. So that would be reset to the March 3rd status calendar at 9 a.m.
Okay.
All right?
Yes.
Hopefully she will get some information that we can resolve this case, but if not, then we just have to keep having you show up until she's ready.
Yes.
All right, thank you.
Okay, thank you.
All right, position 7 was no cross. Position 8, Ms. Githier, have you had a breakout with Ms. Olga?
We have spoke via email, Your Honor. And
That's correct. That's correct, Your Honor.
It's my understanding that they want to proceed with a trial.
That's correct, Your Honor.
And this case is going to be reset for a jury trial and a case management order. Just make sure one wasn't issued before.
I don't believe so, Your Honor.
All right. It's going to be put on a jury trial calendar and a case management order will issue today. Please make sure that your contact information, address, and phone number are all current with the court. All right. Thank you, Ms. Olga. You're free to go. Ms. Wall, you're free to go as well. And all jury trials are in person, not Zoom. Okay.
Thank you, Your Honor. You have a great day.
You too. Position 9 has been reset to March 3rd for a final plea. Is there anyone whose name I did not call in the courtroom? Anyone whose name I did not call on Zoom? All right. We're going to be in recess until the public defense attorneys and Ms. Simmons come back with an announcement.
Judge?
Just 1 second.
Oh, sure.
Yes. Yes, Mr. Gaither?
I know Ms. Riley is in caucus, but just going back to the add-on with Ms. Christine Hacker, who's present, Ms. Riley did give the state's offer on the record, and we would just further notice this case in the next calendar because we're going to decline that offer today. We need more information that I can discuss with Ms. Riley away from the microphone.
They're asking for 40 hours of community service.
Well, here's the problem.
I can't discuss it until Ms. Riley comes.
Sure, understood. So we'll wait till she gets back.
Okay. And I'm also open to non-negotiate, so just throwing that out there.
Okay, okay.
All right, so as soon as the attorneys appear and let me know what they want to do, we'll take that up. Thank you. Ms. Helen, we are addressing the case with Ms. Lukes.
Understood, Judge.
At the podium, please. Yeah. Yes, ma'am.
Okay, so I decided to continue with a public defender for my case.
All right. And with regards to continuing with the public defense, this was it Ms. Riley or Ms. Githiea?
Githiea, Your Honor.
All right. And Ms. Helen, I believe you said you had to still review some evidence?
Yes, Judge, we did request that body worn camera or any dash camera video in Ms. Lou's case, and I haven't received any, but I have requested it.
Okay, and this is the one I was going to reset to March 3rd at 9 a.m. Ms. Githiea, where the state is required to produce the all outstanding discovery, including any body cam, video, audio. I don't know what other kind of format there is for discovery by February 14th, 2023.
Yes, Your Honor.
And the case will be reset to the March 3rd final plea calendar at 9 a.m. Based on Ms. Helen, you can speak to your client based on the review of the evidence that you have, or the case will stand dismissed if the discovery is not produced by the deadline.
Understood, Judge.
All right.
May Ms. Lukes be excused, Your Honor?
Ms. Lukes, did you have any question about what I just said?
No, ma'am.
All right, so we'll see you in person, March 3rd at 9 a.m.
Yes, thank you, Your Honor.
Thank you.
Thank you, Judge.
All right, Ms. Riley and Ms. Simmons. Position.
Yes, Your Honor. We are back from the breakout session. I wasn't able to verify that discovery was filed on the case. However, Attorney Riley and I have spoken through the breakout session. So I would like the opportunity to make sure that discovery is available. Number one, I would like the opportunity to speak over the offer that was relayed today with my client. So Your Honor, if we can place this on a status calendar, that would be great.
Okay, yeah, I'm going to put it on a March 3rd final plea calendar. So what do you mean by you need to verify? Is it there or is it not there?
I don't know. I didn't get a chance to look on Odyssey myself since we've been in court this morning. Like I said, I didn't receive any emails since our other court date from the state. And I know at our other court date, you had expressed to the state to, contact through email. So I don't know if discovery is there. I would like the opportunity to check on that to see if it is, and also review that discovery. There were some things that I shared with the state today, and that may mitigate us resolving this case in lieu of a trial.
This is a reckless conduct case. Was a firearm involved, Ms. Riley?
Yes, Your Honor.
Okay. March 2021 was when we got an entry of appearance by Ms. Simmons. So Ms. Simmons has been as the attorney of record since March of 2021. And Ms. Simmons' discovery was submitted on January 6, 2023. You're telling me that you could not retrieve the discovery on January 6, 2023?
I'm telling you, I didn't even know that there was discovery submitted on January 6th. When we were in court last, At
No, no,
that
no, 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 no. I don't care what you don't know because I can see it. And I deal with all these cases. So the way you don't know is because you didn't look.
I did
Oh,
not
no,
look
no, no,
on-
no. You didn't know because you didn't look.
You're correct, Your
Okay,
Honor. I did
and you
not
have
look-
failed your client by not doing that. Let me put that on the record. Now, where is this video discovery, Miss Riley?
Your Honor, there is no video on this case. It has nothing to do with the video. I believe that Attorney Simmons was saying she has not been able to check because she was expecting an email saying that initial discovery was ready or there.
I am looking at this discovery, and Ms. Simmons, you have no idea how furious I am about this.
Your Honor, I can understand your frustration. May I please explain what I was saying? What I was saying was, you're correct. I did not look on the system because I was used to the customary exchange between the state and I, where discovery is either sent by email or even a courtesy email saying, hey, per your request, here is discovery. So
Ms. Simmons, I have
Your
a
Honor,
word right now in my mouth that is 2 syllables and I can't say it because it's on Zoom. So move on.
Thank you, Your Honor.
Okay, now, this discovery has already been produced. Miss Kalia Marie Harris, is she in the courtroom?
She's on the Zoom, Your Honor.
Yes, Miss Harris. All right. I want you and your client to go into a breakout and discuss the evidence and to discuss the plea offer. And we're going to email the discovery that was filed on January 6th, or would you like to look it up yourself?
Your Honor, whatever you would recommend, I will do so.
All right, Miss, put your email in the chat. Ms. Redden, do you have it? All right, and we're going to send you the paperwork that was filed with the court as initial discovery on January 6, 2023. That was available to everyone who can access this case, including the attorney of records. And then let me know what your client wants to do. If we go to trial, we're going to a jury trial. And that will be scheduled as soon as possible. And that will be an in-person trial, no Zooms.
Your Honor, I would like the opportunity to have this on a motions calendar because
Ms. Simmons, denied. Denied. You came to court expecting an email because that's your usual practice. Trust me, I am so furious right now. I need you to talk to your client. All right, moving on. Okay, as soon as you get the email, Ms. Simmons, put it in the chat to Ms. Redden, and then we'll place you in a breakout with Ms. Harris. Thank you. All right, Ms. Riley is back. Mr. Gaither, you wanted to address the staff add-on case.
Yes, Ms. Christine Hacker.
Christine Hacker, yes, and she is present, yes?
She's present.
Okay. All right, tell me what you want to say, Mr. Gaither.
Okay, so the receipt of discovery is not my argument fully. However, the reason why we are not in a position to accept the state's offer today is because there is nothing in the discovery that I have that implicates Ms. Hacker. Nothing at all. The police report only states that someone called, that the victim called, his wallet was missing, somebody used it, and that was it. Nothing that leads to the arrest of Ms. Hacker, nothing in here at all that even ties her to this crime. Doesn't even mention her name. So now the reason why I'm bringing this up, because I may be the one that's in error. I received this case I inherited it, so I just want to make sure, do I have all of the discovery? Because I may be missing something that I didn't get from my error.
There should be a police report that has a date of November 19th of 2019. And then another
have that
report.
one. Sure. And I'm just saying, I don't have that. What I have, Ms. Riley, is the the incident. What I have, and I don't have my laptop, so that's why you don't see me on video. I'm sorry.
Okay, just 1 second.
I have the discovery.
Just 1 second.
Sure.
Mr. Glanville, could you please give me screen share rights? All right, Mr. Gaither,
Yes,
this is the discovery.
that's what I have. That's exactly what I have.
Yeah.
Judge. Yes.
This is the incident report.
That's what I'm presuming. And there's nothing in that narrative that ties Ms. Hacker. Doesn't even mention her name.
All right. And the witness list, which is Officer Harold with the Milton PD.
I have that. I have the accusation that, of course, mentions Ms. Hacker, as it should, but there's nothing in that incident report that ties Ms. Hacker to this.
Well, Your Honor, there is an additional report because the offense date listed is January 12th, 2020. So there was no arrest made on November 18th, 2019. That is I guess the backstory to the arrest that took place on 1/12/2020. So
My question is that, is there any other written audio or video documentation or evidence created since this incident report?
yes, there is an additional report from January 12th, 2020 that needs to be provided to Mr. Gaither.
All right, and do you have it?
Yes, I will email it to him.
Okay, please email it to him right now.
Yes, Your Honor.
Thank you.
You're welcome.
And that's all we got, sir. Do you have that January 20th report?
No, I don't.
Okay, good, that's coming then.
Quick question. On the certificate of discovery, the box video audio is checked. Is there a video? And again, the reason I'm asking, I'm not making an argument that I didn't receive discovery, knowing that I was a lawyer that inherited this case, so the video could have gone to the prior attorney but didn't make it to me. So I'm just saying, if there's a video, can you resend the link to me?
All right.
Yeah, to my knowledge, there is not.
Okay.
All right. So we have on record, there is no other evidence except this one January 20th. So as soon as you get it, you let me know how you can proceed.
Okay, thanks, Judge.
So we are holding on Christine Hacker pending a January 20th report.
And may I beg the court's indulgence? Ms. Riley gave the offer in the beginning. Can you give it to me again, Ms. Riley? I wasn't able to write fast enough to get the whole.
January 20th, 2020.
No, I'm sorry. No,
No.
the state's recommendation.
Oh,
I wasn't able to write fast enough. So can you beg my indulgence and repeat it?
Ms. Hacker,
From Ms.
Yeah.
Hacker.
12 months to serve 2 days, credit for time served 2 days in anti-theft class and 40 hours community service.
Okay, thank you.
I speak faster than Ms. Riley, so what's that too fast?
I was able to get part of it already from Ms. Riley, so I was able to get the other part from you, Judge. Thank
All
you.
right, thank you. Okay,
And then the other case I have with Ms. Riley is Ms. Yvette Barlow. And what I will ask is, Ms. Riley, could you just give us what the state's offer is? Because I think I wrote the wrong offer down in my file.
Okay, it is 12 months to serve 10 days, balance probated, an alcohol and drug evaluation and any treatment that is recommended, and to have no contact with the victim.
Yeah, and Judge, if that's as good as the offer is going to get, either we may want to consider a non-negotiated plea or have this case placed on the trial calendar.
all right. I'll consider a non-negotiated plea. Ms. Riley, if you could just draft the paperwork according to what the state has demanded and send that to Ms. Redden. We will address this as a plea hearing, non-negotiated. All right. Let me see. Any other announcements?
Your Honor, did Ms. Barlow come into court? I have her.
Yes,
at the
she's
front.
in the
here, she's
courtroom.
here.
She's in the courtroom. Yes, I'm sorry, you were in the breakout. She was here. Yes. Okay, so I'm expecting plea paperwork for position 1, Yvette Barlow, and there was one other case.
Portia Dudley, I think,
Portia Dudley? Okay,
number
4.
yes.
All right, Ms. Barlow, we're gonna get the paperwork for your case and see if we can resolve it today. And your attorney is going to review the paperwork with you. And Ms. Dudley, we're still waiting on the paperwork for you to review. All right. Thank you. Ms. Helen, any more announcements?
I don't believe so, Judge.
All right, we'll be in recess until we get some announcements from Ms. Simmons and then the paperwork for the police. Thank you.
Understood, Judge.
Ms. Riley, Mr. Roth would like to speak with you. Could you put your phone number in the chat to Ms. Redden and we can give it to Mr. Roth?
Your Honor, I have Mr. Raff's number. I will give him a call.
Thank you.
Thank you.
All right, any announcements? Ms. Riley, are you available? Oh, sorry, my microphone's. Ms. Riley, are you available? Yes.
Yes, Your Honor. I just finished speaking with Mr. Raffoff. I don't even think they've come back in the courtroom yet. And I'm still working on the paperwork for Dudley. And I sent the police report to, or the other incident report to Mr. Gaither on Ms. Hacker. And I also have the plea paperwork for Ms. Barlow. I'm not
Okay.
sure if Attorney Simmons has an announcement for you.
Yes, Ms. Simmons, what's the announcement?
Good morning, Your Honor. Thank you again for that time for me to speak with my client. We're just ready to proceed with either putting it on the final plea calendar per what you said earlier, Your Honor.
All right. And Ms. Riley, you've already communicated a plea offer?
Yes,
to
Your Honor.
Ms.
And,
Simmons?
and I
Okay.
emailed it. I put it on the record and I emailed it.
Okay. Are there any
Yes, Your
other
Honor, I do have
outstanding?
it.
Are there any other outstanding discovery matters?
No, Your Honor.
Okay, no other further outstanding matters. I'm putting this down. No more outstanding discovery. This case is going to a final plea calendar, and this will be in person. All right, Miss Keila Harris. All right, Miss Harris, you will need to appear in person at courtroom G33 at 160 Prior Street for the final plea cases at 9 a.m.
And which date did you give us, Your Honor, please?
March 3rd.
Okay, thank you, Your Honor. And that concludes my business. May I be excused as well as my client?
Yes, you both may. Thank you very much.
Thank you so much. You have a good rest of your day, ma'am.
You too. Thank you. All right, Mr. Raffoff, do you have
Number 5 on the final plea, Rashad Hunter.
Yes, sir.
Again, I just picked up that case today. We're trying to resolve it. We're not going to resolve it today, but we would ask that the case be put on another final plea calendar.
What's holding it up?
Pardon?
What is holding it up? What is holding it up from having a plea today?
Your Honor, the state needs to speak with someone.
All right. I guess that says specific as I'm going to get. So.
Well, it can go to a final plea or a trial. I think this can be worked out. So that's why I asked for the final plea, but.
Reset final plea. Are there any other outstanding discovery matters?
I just got the case today. I haven't.
Let me see what else is out there.
But I know what happened. The victim's here. I talked to both of them. So I'm assuming I got a good picture of what happened. But again, I have not seen the discovery.
All right, discovery was submitted on December 21st, 2022. There were 2 filings of discovery. I don't see any indication that I have accusation, witness information, police incident report. There appears to be a video shared via evidence.com, a 911 recording, warrant and citations. All right, Mr. Raffoff, that's all out there now. It's been out there since December of 2022. And let's see what was the second submission. It appears to be the same thing. And these were submitted by Ms. Marshall Story. So videos out there, documents out there, there's no further outstanding discovery that I can see at this juncture. So I'm resetting it to final plea calendar at 9 a.m. in person.
Was that March the 3rd?
March the 3rd.
Thank you.
All right. Okay, Mr. Rashad, the Public Defender's Office is your attorney. You're coming back on March 3rd for a final plea. All right, I'm not taking any more delays in this case. Thank you. Ms. Redden, any progress on documents for Ms. Redden? No. Mr. Glanville, do we have anyone in the breakout room?
No, Your Honor.
All right, thank you. All right, we'll hold for further announcements from the council. Thank you.
And Judge, I just want to say I don't have any other cases and I don't have any other announcements, Judge.
Okay, that was Mr. Gates. Okay, all right then, Ms. Allen, thank you so much. You're free to go. Thank you.
Thank you, Judge. I'll stay, but thank you.
All right. Uh, Miss Riley, have we sent all the documents? Ms. Rockoff, you're waiting on a plea document, right?
Yes.
Mr. Gaither is waiting on a plea document.
I have sent the documents for Miss Barlow to both Mr. Gaither and Miss Redden. The paperwork for Miss Dudley, I'm working on now, Your Honor. I have to go in and amend the accusation. I cannot take the plea until that is at least done with the clerk's office. It may not be accepted, but I have to file it.
And also for Miss Hacker?
I did that prior to speaking with Mr. Raffoff on the phone.
Okay, so Mr. Rockoff, you have the plea paperwork for Miss Hacker?
I'm sorry.
That was Mr. Gaither's place.
Oh,
Oh, yeah, I didn't recognize.
sorry, thank you. All right, now Mr. Gaither's in the office, in the courtroom, so let's see.
We're ready, Judge.
Okay. Mr. Gaither, could you have Miss Hacker and Miss Barlow?
Yes.
And
This actor is in the hallway for Julie. See that thing?
okay, and then Mr. Rockoff has Miss Dudley, whose paperwork we're still waiting on because of we have to change the accusation and system. All right, okay, thank you. Thank you. All right, Miss Riley, we're going to address. That's it. Miss Riley, are you there? Make sure she's present.
Yes, Your Honor.
We're going to address the plea for Yvette Barlow. This is position number 1 on the final plea calendar.
Your Honor, I only have one odyssey. If I stop amending the accusation now for the Dudley plea, then I have to start all over.
Oh
And
my
I can't
goodness.
pull up.
Okay,
We can wait a few minutes, Judge. That's no problem.
we'll
Thank
wait.
you.
Let me know when you're ready. Thank you.
Thank you for the time, Your Honor. I would be ready on either Ms. Barlow or Ms. Hacker.
All right, appreciate it. Thank you, Ms. Riley. Okay, Mr. Gaither, Ms. Barlow. Oh, I've lost Mr. Gaither now. Trying to keep everyone. There we are. Yay. Okay. All right. This is State of Georgia versus Yvette Barlow, position number 1 on our final plea calendar for this morning. Accusation number 20 CR 001454P. Ms. Barlow is present in court with her attorney, Mr. Frank Gaither. She was accused of simple battery from an incident date of June 7, 2018 in Fulton County, Georgia. Ms. Barlow, you have the right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Frank Gaither from the Public Defender's Office. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Riley, what are the terms of the state's offer?
Your Honor, this is a non-negotiated plea. I would like to put a factual basis on the record.
All right.
On June 7th, 2018, officer was dispatched to 352 Holly Street Northwest in Fulton County in reference to a dispute. Upon arrival, the officer made contact with the caller identified as Yvette Damons. So we have 2 Yvettes. Ms. Damons advised she was staying at the listed location with her friend, the defendant, Yvette Barlow, for a couple of weeks. Ms. Damons advised that on the listed date, she returned to the location to get her belongings and saw them on her on Ms. Barlow's front porch. Ms. Damons advised Ms. Barlow was drinking most of the day and was heavily intoxicated. Ms. Damons advised that she wanted to get her belongings so she could leave the location. So she asked for officers to come so she could get her belongings. As the officer was speaking with Ms. Damons, Ms. Barlow began interfering by screaming obscenities at Ms. Damons and slamming the front door shut, or slamming the door shut. Ms. Damons went inside to gather her belongings, and as she was walking out with her items in front of the officer, Ms. Barlow punched Ms. Damons in the face, causing her to lose her balance. Ms. Damons advised she was fine and did not want to be transported to receive medical attention. Ms. Barlow has 33 cycles on her history, to include 2 counts of obstruction of officer, an additional simple battery, an aggravated assault, illegal drugs, marijuana charges, an additional aggravated assault, an additional charge of obstruction. So that's now 3 obstructions of officers. And I'm only at cycle 15, Your Honor.
All right. What's the state recommending?
If this was a negotiated plea, the state's offer was 12 months to serve 10 days, balance on probation, an alcohol and drug evaluation, and any treatment that would be recommended, and to have no contact with Yvette Damons. But the state would ask at this point, since this is not negotiated, for substantial jail time, considering the circumstances that Ms. Barlow punched someone just trying to retrieve their items in front of a law enforcement officer, and she has several arrests for obstruction and several arrests for aggravated assault. Thank you.
All right. And she has served how many days so far?
When I looked up this arrest, Your Honor, she has served no jail time for this arrest.
All right. Mr. Gaither?
Yes, Judge. My understanding, she spent 3 or 4 days. Someone can verify that, though. I don't have a way to verify that right now.
This was back in 2018.
Yes.
At least I'm looking at the Fulton County jailings. I don't see any.
Okay.
So 2010, 2017 was booking. This was an incident from June 7, 2018. I have a booking from February 2nd, 2018.
Okay.
The release date of February 17, 2018. And so I don't have anything with regards to this incident.
Okay, don't worry about it. Don't worry about it. Okay. Judge, the state made an effort to make sure that you were aware of her arrest, but I didn't hear whether those were actually convictions or not. And so she's not being charged with obstruction. She's not being charged with aggravated assault. She's not being charged with any of those other charges other than simple matter of punching someone in the face. What was not told was that Miss Yvette Damon was staying at the residence, that's right, for a few weeks to get herself back on her feet. And both parties were drinking that day. Words were said, it's a typical, you said some things, I said some things, fight broke out. Miss Yvette Damon's called the police. When the fight was already ongoing before the police got there, okay? When the police arrived, that's when, as my client, she has an anxiety to make sure everyone knows this, that what the officer didn't see was Miss Damon spitting on her, which, yes, then Miss Barlow lost her temper again and punched Miss Damon in front of the officer. But this is not a situation where the officer comes on the scene and all of a sudden Miss Barlow attacked her. That is our position, okay? That's why our recommendation with this would be the 12 months with whatever. I thought there was some jail time already, but this should not be a jail time case for a punch in the face. To 12 months, my client is willing to undergo alcohol, drug evaluation, and treatment as needed. And we ask that be suspended upon completion. And instead of no contact, to have no violent or harassing contact with Miss Yvette Damon. Why? Because they've been chit-chatting and texting each other on the phone since 2018. And so that is our recommendation.
Repeat that again, please.
Yeah, 12 months,
Alcohol,
drug and evaluation and treatment as needed. But then we ask that be suspended upon completion because we understand that, suspended upon completion. And then the next step, instead of no contact, no violent or harassing contact, because they have still been communicating with each other since the incident. And as our understanding, Ms. Damon may live in Augusta, so she doesn't even live in Metro Atlanta anymore.
okay. Any response, Ms. Riley?
Your Honor, I would first object as there has been, I was reading from the actual incident report as observed by the officer, but there's no way to corroborate the account of what happened before without Ms. Damon's being present to testify. So I would object to that. And if they are fighting each other, that furthers the need for them not to have contact with each other.
Well, here's the problem. You got to tell your victim to stop texting my client then, and that's going to put her in peril because if Ms. Damon texts her like she did before, how's the court case going? Then what is my client supposed to do? Block her? Yeah, I guess she would have to.
I think you just answered your own question.
But okay, that's fine. But then she can't tell her to not call me.
She can block her.
She can, exactly. But as from an argument of logic, I'm not trying to set my client up for failure. Okay,
I understand.
that's all I'm saying.
The court has reviewed the information. I've also gone through some of the prior cases with Ms. Barlow. She will be placed on, if she decides to, Ms. Riley, Ms. Barlow wants to enter a plea of nolo contendere. What's the state's position on that?
The state would vehemently object to a nolo plea in this case, Your Honor.
All right, Mr. Gaither, you circle nolo. What's the position on that?
Our position is that we plead nolo, Judge. At the end of the day, no matter what Ms. Barlow's record is, it's a punch to the face case. That's what a jury would be hearing, a punch to the face. Okay? No more than college kids who get arrested at any football game, get into a fight, bar fight. I'm not trying to minimize it, but it's a punch to the face case. It's not aggravated. There's nothing else to it. And I'm just simply pointing out what our position would be, that the story that would be told about the other part that wasn't told today. But that's why we're foregoing all that and trying to resolve it by entering a non-negotiated plea, Judge.
I'll accept a nolo contendere plea, but considering the age of the case and the remoteness in time, also with the fact that I don't have any indication that Ms. Barlow has had any more further additional infractions with the law since this incident. However, I will consider 100 hours of community service in lieu of 10 days of jail time, in addition to alcohol and drug evaluation. She will report to probation for 12 months. I will waive her probation fees for the first 6 months, and then she will start paying probation fees after 6 months. And this is in light of the fact that Ms. Barlow has a significant criminal record history that doesn't warrant non-reporting status.
Okay, you said you would do the 100 hours community service.
And so it would be 12 months on probation, 100 hours of voluntary community service, and alcohol and drug evaluation to be completed within the next 90 days. The 100 hours community service, she can perform that over the 12-month period. Her probation fees are waived for the first 6 months, which is February, March, April, May, June, July. And then she will start paying probation fees from August 1st, 2023 onwards.
And just so we're clear, Judge, the court is not imposing a 10-day jail term.
100 hours community service in lieu of 10 days of jail.
Thank you. We'll accept that, Judge.
All right. This is a non-negotiated plea. And the state wants to put an objection on the record.
I'm sorry, Your Honor, the state.
The defendant has accepted 12 months probation. Instead of the 10 days of jail, she's agreed to 100 hours of voluntary community service and alcohol and drug evaluation, 12 months of reporting to probation, 6 months probation fee waiver, and this will be a nolo contendere plea.
Yes, the state renews its objection to a nolo. Yes, Your Honor.
Okay. So noted. Thank you. Ms. Barlow, and may I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. And Mr. Gaither, do you stipulate to the venue and ID?
We do, Judge.
All right. Ms. Barlow, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you or inducing you to take this plea today?
No, ma'am.
Are you doing so willingly, knowingly, and voluntarily?
Yes, ma'am.
If you decide to enter a plea of nolo contendere to simple battery, you would have to give up your constitutional right to go back to court, to have a trial, to be able to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, yes, ma'am.
How do you plead to one count of simple battery?
Nolo.
I accept your plea of nolo contendere. Your sentence is 12 months probation. You will complete 100 hours of voluntary community service while on probation, and an alcohol and drug evaluation and any treatment that's recommended, which means, Ms. Barlow, no alcohol
Yes, ma'am.
for the next 12 months.
Yes, ma'am.
You're also to have no contact with Yvette Damons. So as you've heard, if she reaches out to you by phone, by computer, all you need to do is block the source.
Yes, ma'am.
All right?
Yes, ma'am.
You must report to probation next Thursday at 132 Mitchell Street in downtown Atlanta.
Mhm.
All right?
Yes.
You may have to fill out some probation information before you leave.
Yes, ma'am.
You will report every month between now, February, and the end of July of this year. You don't have to pay probation fees.
Yes, ma'am.
But from August 1st, 2023, you need to continue reporting to probation and start paying probation fees.
Yes, ma'am.
You might be subject to random screens for alcohol, so make sure you do not consume any.
Yes, ma'am.
Any questions, Mr. Gaither?
No questions, Judge.
Your 100 hours community service can be done at any non-profit agency like Salvation Army, Good Samaritan, food banks, and so forth. Okay,
Yes, ma'am.
thank you.
Have a seat now. Come give you the paperwork. whatever. Mike, you have a case to deal with? Okay, let me go check on this.
Mr. Ross?
Steve has the paperwork on Miss Portia Dudley, but she points out a mistake on the recommendation. That's why she did the community service and the anger management ahead of time, that it was her understanding that the probation balance would be suspended or the case would terminate.
I thought we had already discussed it. Yes, that is the case.
Well,
If
it
you
doesn't
want
say-
to, I mean, I don't know, are you saying I didn't put that on the paperwork? If you
No,
want
it's
to
not written
add.
on there.
I'll include that in the paperwork and it'll go on record. Are we ready to proceed?
Yes, we're ready.
Okay, Ms. Dudley, please come forward. And this is a nolo contendere, please.
Yes, Your Honor. No record, no prior record.
And Ms. Riley was probation to terminate upon completion of the 6 anger management classes and the community service, correct?
Yes, Your Honor.
And she's done 8 anger management classes according to the paperwork we provided and 46 hours of community service already.
All right. This is State versus Portia Dudley, case number 20 CR 005-720E. Ms. Dudley was originally charged with, sorry, let me get to the case, simple battery domestic violence from November 20th, 2020, as a cross-defendant. Would that be correct, Mr. Rock?
Yes, Your Honor.
All right. Ms. Dudley, you have been advised of your right to remain silent, and your attorney is Mr. Michael Ruff with the Public Defender's Office. Pursuant to discussions between your attorney and the prosecution, you have accepted the terms of the plea recommendation to plead nolo contendere to disorderly conduct in exchange for a recommended sentence. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes. Thank you. All right, Ms. Riley, what is the terms of the plea?
Yes, Your Honor. It's 12 months probation, 6 anger management classes or 6 hours, 40 hours of community service, to have no further violent or harassing contact with Shantavia Stewart. The balance of this case is suspended.
All right.
Yeah.
Mr. Ruff, do you stipulate to the factual basis, venue, and ID for a charge of disorderly conduct?
Yes, Your Honor.
All right, and your client accepts these terms?
Yes.
All right. And Ms. Dudley, I've reviewed your certificate of completion for the 8 hours of anger management classes, which is 2 more than what was required by the prosecution, as well as you've completed 6 hours of voluntary community service with the Active Life in LaGrange, Georgia. First of all, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
Yes.
Are you satisfied with the services of Mr. Roth?
Yes.
And are you entering this plea freely, willingly, knowingly, and voluntarily?
Yes.
Understanding that if you enter this plea, the case will be closed. There
Yes.
won't be any further scheduling of this case, there will be no trials of which you will have a right to have. You will not be able to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the original charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of disorderly conduct?
Nolo.
Thank you. I'll accept your plea as you have completed the conditions recommended by the state. Probation is no longer required. This case is closed, and thank you.
Thank you.
Just remember, you can't have any violent contact with Shantalia Stewart, okay? Thank you. All right. Here's the plea disposition, original paperwork. Thank you. Yes, Ms. Faith.
I have an announcement now from Ms. Christine Hacker, the add-on Orca B calendar. I received the affidavit for arrest warrant that was emailed to me. I've gone over it with my client, Ms. Hacker. And I looked in our file, and my predecessor filed a motion to suppress along with other, like the consolidated motions package. I asked this case gets placed on a motion calendar. I believe there was a suppression issue that needs to be raised in this case, and I will particularize that motion.
All right.
Yeah, and I'll do that ASAP as well.
Let me see the motions calendar. When was that motion filed?
It was filed, let me see, on or about May 7th, 2021. Let me see, can I find the stamp file date? Yeah, May 7th, 2021. Looks like the entry of appearance, and it was probably motion reserving right to file additional motions, a motion to suppress. Looks like the entry of appearance along with other motions were filed at the same time.
May 7, 2021, you say?
Yes, it was filed by Miss Elizabeth Hogue.
Yeah.
Okay. And please forgive me if I butcher the name.
No.
Okay.
So it's just your standard litany of motions without any.
Right, and it needs to, and I'll particularize it, especially after now receiving the affidavit for arrest warrant.
Do you have a proffer right now on your motion to suppress?
Yeah, the proffer I have is that the officer lacked probable cause to search the vehicle. She didn't give him permission to search. He just said your car was not insured, and nowhere in the arrest affidavit did he say she gave me permission to search, nor does it say I placed her under arrest and then did a search incident to arrest. None of that language is in there. It's just, I told her I smell marijuana. Your car is not insured, and when my backup officer arrived, I searched the vehicle. Okay?
No.
I searched the vehicle.
May I see that affidavit, please?
Yes, ma'am.
Thank you. Oh, this is the warrant.
The narrative is in the arrest affidavit.
January 12th, okay. Suspended registration, no insurance, so that was for the stop of the vehicle, okay. All right. I can schedule this for, I mean, there's nothing in there that leaps out of me and says that to make a decision right now, but I'll go ahead and reset this for a motions calendar on March 2nd. Oh, excuse me, it's April 21st. My motions calendar is April 21st, 2023 at 11:30 a.m.
And that's in person, right, Judge?
Yes, in person. So we'll need to subpoena the officer who, or an officer from that agency. Miss Hacker.
Yes.
Your case is being submitted by the prosecutor general's office. And the reason I'm not doing this to scare you, but this is the cold hard facts in this case. Right now, the case is still with our court and it's going to be scheduled for a hearing in April. The closest date I had is April 21st, which is 2.5 months away. All right. The prosecutor has advised the court that your case is being submitted to the district attorney's office to be considered as a felony charge. All right. So I'm sure your attorney has already spoken to you. I have no guarantee that between now and April 21st, that they will accept it or decline it as a felony. If they accept it as a felony, then the April 21st hearing will not proceed. The case will automatically be transferred to Superior Court and you will be accused, your case will be accused as a felony charge.
Well, I get to keep my same lawyer? Oh, okay.
So before you decide whether you want to absolutely decline the plea, Mr. Gaither, please advise her of that, because if it goes to Superior Court, it's out of my hands. I have to take it off the calendar.
I'll be the same.
Okay, then I.
It'll fall on me. I'll follow the case.
Okay.
Yes?
Yeah.
Okay, so scheduled for April 21st, 2023 motions calendar at 11:30 a.m. in person. Ms. Riley, please make sure you subpoena the appropriate officers. Thank you. All right, and that concludes our Orca calendar. Just to go over the calendar, position the add-on, Ms. Hacker, that's reset to motions calendar, April 21st,
April 21st at 9 a.m.
11:30 a.m.
Oh.
Okay.
You too.
Final plea calendar. Position 2, Barlow was a plea. Position 2, Biblioni was a plea. Position 3, Coleman is reset to the final plea calendar for March 3rd. Position 4, Dudley was a plea. 5, Hunter is reset final plea March 3rd in person. Position 6 is reset for a jury trial. Mr. Eichert, a case management order was issued. Position 7, Luke's is reset to March 3rd at 9 a.m. for a final plea. Discovery is required by February 14th or the case stands dismissed. Okay, the position 8 is reset to March 3rd, 9 a.m. Status calendar, discovery required by February 14th or the case stands dismissed. Position 9, Shantavia Stewart was a plea. Status calendar, Orca E, position 1, Timothy Fulton was a plea. Position 2, Keela Harris was reset to March 3rd, final plea calendar in person. Position 3, Alexander Hill is reset to the March 3rd status calendar to address a motion to be filed by Attorney Josh Schaefer. This is requirement of in-person for all parties concerned. Position 4, Shield is null frost. Position 5, Shivers is reset for a jury trial. I think a case.
I'm sorry, Your Honor, if you could go back to position 4.
Shield, was that a null frost?
No, Your Honor.
Oh, that wasn't, sorry. That was an FTA. Okay. Okay, sorry. Yeah, Mr. Gaither or Ms. Roth? Oh, that was one we were waiting for her. That's one, Mr. Roth. Yeah, sorry. Any word here?
Yeah, I talked to her last week. I expect her to be here. We called her and emailed her today many times and no contact whatsoever.
All right, Ms. Redden, we're going to draft the bench warrant This is going to be a $1,500 surety bond. Of course, Mr. Ruff, if you hear from her, please let her know she needs to file a motion to set aside the bench warrant, and we'll schedule it for a hearing.
Thank you.
All right. Position 5 is reset for a jury trial. Shivers, did we do a case management order in that one? Okay, one's already on file. Position 6, Joanne Slater is reset to March 3rd. Ms. Miller is not available, the attorney. Position 7 was not crossed. Am I right about that? Please tell me. Am I
That
right?
is correct.
Okay. Position 8, Jessica Wall is reset for a jury trial. Case management order was issued. Position 9 is reset to March 3rd, 9 a.m. for a final plea. And that concludes our calendar. Thank you, folks.
Thank you, Judge.
Thank you.
All right, and we didn't hit 12 noon, which is a good, I'm gonna hear griping in the background, but 12
Oh.
noon.
Oh, Your Honor,
Yeah,
just so you'll know, I have 2 motions to set aside bench warrants. I'm gonna prepare for you. It was 2 people called me up, and one actually had a change of address, but she changed her address with the clerk's office. And the second one, he was telling me, look, he evidently, his pretrial officer switched and there was some miscommunication, so he never got notice of the court date. And both of them are very concerned. And one of them, the young lady, is 7 months pregnant. So I have 2 motions I'm going to prepare to send to you. Just want to let you know it's coming down the pipeline.
okay, well.
Okay.
Oh, sorry. Which one was this?
Position number 8.
Yes, final plea, position 8, final, position 8, final plea. Is reset for a final plea, sorry.
I'm sorry, could you repeat that, please?
Position 8, Desmond McLeod is reset March 3rd on the final plea calendar, not the
Okay.
status calendar.
Okay, thank you.